The legal opposition to the development of the Obama Presidential Center appeared to have run its course when a Seventh Circuit Court panel ruled last month that opponents of the development did not have the standing in federal court to pursue their objections. But now, the group Protect Our Parks, which filed suit against the City of Chicago and the Park District more than 2 years ago, has filed a motion for the full court to reconsider its case. And if that fails, they are not ruling out appealing to the U.S. Supreme Court. Joining us now to discuss this latest development, HERBERT CAPLAN, founder and president of Protect Our Parks. And we should note, we did invite the Obama Foundation to participate in this discussion. They declined our invitation. Thank you for joining us, Mr. Kaplan.
Thank you. I appreciate the opportunity to speak.
So, very briefly, in a nutshell, what is your group's argument against the Obama Presidential Center in Jackson Park?
Well, our basic argument is all legal. There are statutes that prohibit doing what the Park District and the city have done. And we believe that the actions of all the city officials who had a hand in this have violated the public trust, which is another constitutional argument we're relying upon.
Are you opposed to the center in total?
Oh, not at all. In fact, we keep saying it over and over again, and nobody seems to listen. We're all in favor of an Obama Presidential Center in the South Side, and we've suggested an ideal location that is not in a protected historic public park, just a few blocks west in the Washington Park neighborhood. If the Obama Foundation would agree to that, they could start building it tomorrow.
The Seventh Circuit Court of Appeals, in rejecting your argument, said you don't have standing to even make this case. What's going to be your argument if and when they actually allow a reconsideration?
Well, we think they completely misunderstood the situation. I mean, the basis of their ruling was they said that there was no showing that Protect Our Parks or its members or any of the class of city taxpayers and citizens are going to be injured by what happened. And yet our lawsuit specifically details all the ways that the public interest is going to be harmed, and the interest of the plaintiffs, us, is definitely going to be harmed. And we think the court just misapprehended it. And the petition for rehearing, we hope to make clear that if we do not have standing to sue, that what the court has ruled is going to make it impossible for many public interest and 501c3 organizations to do their job, because there are hundreds, maybe even thousands more out there who are exactly in the same position as we are and are filing lawsuits, and heretofore in other courts have had no difficulty overstanding the suit.
You've told our producer that some people have called your opposition to this library center in Jackson Park to be racist. What do you respond to them?
Oh, I'm so insulted by that. The very opposite is in our mind. You know, our whole argument was that Jackson Park does serve the interests of the majority African American residents in South Shore that are nearby the Jackson Park. And by permitting Jackson Park territory to be taken away and to build something that's non-park and recreational oriented, like a 235-foot Obama Tower, is destructive of the interests of the African American community. And I think that everybody has failed to look closely at the facts of the case. And I think that our opposition has tried to trade on this racist slur in order to distract from the legal issues that we've raised.
You face very long odds and very heavy hitter opposition on the other side. How do you maintain any optimism about this?
Well, I guess my optimism is based on my analysis of the case. You know, before we ever filed the lawsuit, I took about a year researching this, looked through all the statutes, looked through case opinions, looked through any comparable situations that existed in other parts of the country. And I came to the conclusion that our lawsuit would be based on principles that were so certain and positive. I expected to get an immediate ruling in our favor shortly after we filed the lawsuit. Well, I didn't realize that other people were influenced in other ways.
Your motion for reconsideration faces long odds. There is a real likelihood, I think you might agree, that the Seventh Circuit is not going to give you the reconsideration. And if it does not, then your only recourse is the Supreme Court, right? Well,
actually, we have multiple recourses, depending exactly on what the Seventh Circuit may say in response to our petition. We've already been considering immediately filing a petition for certiorari to the U.S. Supreme Court. And we have reasonable expectations that the court would consider it, because the issue that we're going to raise, this issue of standing to sue, not only applies to protect our parks, does not only apply to Jackson Park, but would have an effect on similar public interest groups all over the country. So we think that the issue involved is of such immediate importance that we think we can persuade the Supreme Court that they should immediately take up the issue and decide the case.
Well, to be continued. The fight goes on. Herbert Kaplan of Protect Our Parks, thank you so much for joining us on Chicago Tonight.
Okay, thank you. Once again, I appreciate the opportunity to express our side of this case.